We got breaking news just hours after, literally hours after the United States Supreme Court ruled in earthquake-shaking manner that federal judges no longer have the ability to issue universal or global injunctions. They've got to take on the Trump administration one case at a time, one set of plaintiffs at a time, and they can't fashion relief to meet the challenge of, for instance, an order trying to rip away birthright citizenship. They can't do that by nationwide injunction. Well, Justice Kavanaugh in his concurrence said they can just use a class action vehicle. And Justice Sotomayor said, just use a class action. Okay, we're ready. A new class action motion has been filed in Maryland just hours after the Supreme Court shot it down. And at the same time, a request that Judge Boardman issue a temporary restraining order to restrain on behalf of the putative class, to restrain the executive order that tries to deny birthright citizenship to babies who are born or about to be born throughout the country. You asked for it, MAGA majority of the Supreme Court, and just hours later, because they were ready, the lawyers for public interest groups have struck again, filing their motion with Judge Boardman in Maryland. One interesting side note about Maryland, Donald Trump just 2 days ago sued all of the federal judges in Maryland, including Judge Boardman, on a matter related to immigration policy. So she is a defendant in her official capacity in a case brought by Donald Trump and his Department of Justice. Let's do justice right here on Legal AF and talk about this breaking news. Now, I just reported it. I have a great hot take up right now with Leah Littman, constitutional law scholar extraordinaire. She has a show called Strict Scrutiny, and she and I dove into this ruling. We call it the Casa Inc. case, because that's the name of some of the plaintiffs, in which the Supreme Court took 100 years of precedent, allowing federal judges to use their inherent authority and their own judgment to fashion remedies that meet the moment. If a president is going to have abuse of power to try to rip away birthright citizenship to every baby born in all 50 states, then a federal judge, you would think, should have the power to issue an injunction, a universal injunction to stop that. Not so, says the Supreme Court and the MAGA majority written by Amy Coney Barrett. Let's just toss that into the trash can. They basically said, and I'm paraphrasing, but this is the essence of the decision. No one has the power to declare universally for all 50 states whether something is constitutional or not, except for the United States Supreme Court. So the quicker you get an individual case up with us, the better. And trial court judges, you can't enjoin, you can't block nationwide, even though 3 separate judges, Rhode Island, Massachusetts, Maryland, and Washington, all ruled that nationwide injunctions were appropriate because of the nature of the executive order by Donald Trump to try to take away birthright citizenship. So in the Supreme Court decision just hours ago, they said, well, we're not reaching the merits of birthright citizenship. We're talking about procedure, and we don't like the procedure. The procedure needs to be as follows. You bring an individual action challenging a abuse of power, what you claim is an abuse of power by the president, or you bring it like a class action, talk about that in a minute, under Rule 23, and then it'll go up through an appellate process, and then it'll get to us eventually, and that's how we declare a nationwide declaration of rights about a attempted abuse of power under the Constitution. In the meantime, the babies, what about the babies that are born now in red states that are not, there's 47 states that have not gotten an injunction because we were relying on the nationwide injunction powers of the 3 different jurisdictions. Now, as I said with Leah Littman, how quick do you think, Leah, I said to her, they're going to run into court? They have the papers already drafted. And within an hour of our hot take, we have the filing. We have an emergency motion for class-wide temporary restraining order filed in Maryland in front of Judge Boardman. We also have the memorandum in support of a motion for class certification. Let me just read to you from the motion for class certification, quoting Justice Kavanaugh. You can also quote Justice Sotomayor as well. It says, as this court has already recognized, the executive order about birthright citizenship, taking it out of the Constitution, is unlawful on its face and defies centuries of precedent and practice. And this court has also recognized injunctive relief. Protecting everyone harmed by this executive order is appropriate to avoid irreparable harm. The Supreme Court has now instructed, 2 hours before this motion was filed, that in such circumstances, class-wide relief may be appropriate. Citing to the decision this morning, Justice Kavanaugh concurring, quote, noting that the district courts may grant or deny the functional equivalent of a universal injunction, for example, by granting or denying a preliminary injunction to a putative nationwide class under Rule 23. Let me break that down. You either have a single action, right? You or a group of people, something less than a class, suing to avenge your rights, to protect your rights, either because there's been a personal injury, a breach of contract, a tort, a constitutional violation, you name it. And you bring that into a courtroom. That's an individual action. Then we recognize under certain rules of civil procedure what we call collective action, either class action or other type of collective action, where a group of people join together who are similarly situated, whose numbers are great, we call that numerosity, whose claims are all typical of each other, typicality, numerosity, typicality. These are all the elements for class action. When you have a class that you'd like to have certified, before it's certified, we call it a putative class, a potential class. A class representative must represent them with a law firm. And this way, they're able, without having to have 1,000 different lawsuits, they're able to have their issues, and for a class that is similarly situated, to have one judge make a ruling. There's other different ways to do things like that. There's multi-district litigation, but I'm focused now on class action status. And this was a part of the order by Judge Amy Coney Barrett that the other 6 or 5 joined in, where they said, just use a class action. Sotomayor, in her own dissent, similar to Kavanaugh, said the following. She said, and I quote, "The parents of children covered by the citizenship order would be well advised to file promptly class action suits and to request temporary injunctive relief for the putative class pending class certification." She wrote that got published in the morning at 10, and by 1 o'clock, we had exactly what she asked for. So they also asked, while they're at it, to get a temporary restraining order in place. I think, and I'll come back here to Legal AF to give you the update, but here's what I think is going to happen. The judge is ultimately going to certify this class. Trump administration is going to oppose it. They don't want class certification either. Judge is going to certify the class. And this class is going to be defined as all of those people similarly situated to the plaintiffs who were born from parents who were born on U.S. soil, regardless of the citizenship status of their parents. That once that class is certified, she will then enter a temporary restraining order. The class goes first. The temporary restraining order goes second. The temporary restraining order, this is what they're seeking in the temporary restraining order. Let me read to you from that. Plaintiffs respectfully request that the court immediately, without awaiting further briefing, I'm not sure they do that, enter a temporary restraining order prohibiting application or enforcement of Executive Order 14-160 against any member of the putative class of all children who have been born or will be born in the United States on or after February 19, 2025, who are designated by executive order to be ineligible for birthright citizenship, and their parents, to direct the defendants to file a brief a week from now stating the reasons why they oppose preliminary injunctive relief, and then give them a reply brief, and to find no security is appropriate under Rule 65C, no bond. I think the judge might set a bond. It'll be a very low bond. I think she does this. I think Judge Boardman certifies the class. I think she allows for briefing. She asks for fast briefing, like in the next 5 days or so. She maybe holds oral argument or a hearing in her courtroom, and then she issues the class action, which is what Kavanaugh said should happen and what Sotomayor said should happen. What happens next? Well, coming out of Maryland, it'll go up to the 4th Circuit Court of Appeals, which is a moderate to liberal circuit. They will then likely affirm Judge Boardman, refuse the motion to stay. It'll then be an emergency application by Donald Trump and the Department of Justice and his Solicitor General, John Sauer, to the United States Supreme Court, right back on it, but now on the substance. But there'll be 2 arguments: whether the class certification was appropriate by the judge, whether all the elements were met under Rule 23 and the case law interpreting Rule 23 of the Rules of Civil Procedure. That'll be the first argument. It's not properly certified as a class under Rule 23. That'll be Trump. Second argument will be them defending finally the merits of birthright citizenship, something that was wholly ignored in the briefing at the United States Supreme Court level. And then the Supreme Court, on an emergency application, perhaps with further briefing, which is likely given how momentous this decision is, maybe with an oral argument over the summer or in the fall, is going to make a decision. They'll also make a decision whether to stay the ultimate decision of the Fourth Circuit Court of Appeals or not. They might do an administrative stay to allow for briefing and oral argument over the summer with a ruling, or they may try to roll it over to the first Monday in October and the regular term. The problem is these children, these babies that are in purgatory in the meantime. And that's what the motion for class certification talks about. What about, I'm not making it up. What about the babies that are born? Because red states, there's only 3 states where there's an injunction, all of which have to be modified now based on the Supreme Court ruling. It's like Rhode Island, Maryland, and Washington State. What about the other 47? What about the red states, the 23 red states where a child is born after February 25th, 2025, and then his mother applies for assistance, federal aid, some sort of disability aid or food stamps or some other type of assistance? What happens? No, you're not a citizen. Well, how can you say that? Because there's an executive order that says you're not a citizen, but that violates the 14th Amendment. But a federal court at the Supreme Court level hasn't ruled that. You see the mess that's been made by the United States Supreme Court. That's why Ketanji Brown Jackson, Sotomayor, and Kagan opposed. They said, nationwide injunctions are appropriate in certain circumstances when you have a nationwide deleterious impact based on abuse of power of the Constitution by Donald Trump and by a president, but not to the MAGA majority. They've only hated nationwide injunctions when it's the people opposing Donald Trump. When it was against Biden policies, they never even talked about nationwide injunctions. They would complain about it. Kavanaugh used to whine about it a lot, along with Gorsuch in dissents, but they never took it on. That's why we knew we were in trouble when they asked to hear a full briefing on nationwide injunctions coming off of birthright citizenship. We were like, oh, here we go. So we'll continue to follow it right here on Legal AF. Take a moment, hit the free subscribe button, come right back, rinse, repeat, and continue to help us on this pro-democracy channel. Till my next reporting on Legal AF, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.